The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon. Welcome to Marshall, Parker, and Weber's webinar entitled 10 Misconceptions About Paying for Long-Term Care. My name is Tammy Weber. I'm the managing attorney here at the firm. And I also have with me Heather Kohler, who's a case manager extraordinaire, and she's going to contribute as we speak today. Now, as everybody knows, when we talk for a half an hour about a complicated subject, we're not going to be able to hit on every single point. So this is my little lawyer disclaimer that all cases are different. It's not one size fits all planning, and this will just alert you to some facts and considerations that might apply to you or to your clients if you're a professional listening today. And also, everything that we talk about today is the law in effect now, December of 2017. As you're listening, there is a question and answer box that if you have a question, we'll try to get to them. And so we're going to start with just a little scenario. When you talk about long-term care and paying for it, it's good to have a little background. So today, we're going to have Bob and Sue. And they're married, and they have one child, Rosie. And Rosie's married to Rodney. Bob has to go to the nursing home. In terms of assets, they have $100,000 in a joint checking account. And Sue has a money market that she owns with her daughter, Rosie, in the amount of $50,000. And they have a house that they purchased a while ago for $100,000, and it's now worth $500,000, and no debt at all. So Bob and Sue are talking to Heather and I, and they've talked to their friends and the general practitioner attorney, and they don't really have all the answers. So the first thing that they say to us is our first misconception: Medicare covers our long-term care payment. So let me just review that if you need long-term care, which is help with your activities of daily living, most people, they think of it as a nursing home, but sometimes that care happens in your home. There are various types of payment. The first is private pay, and most people don't like this. And I will share with you, under the current average cost in Pennsylvania, average private pay is $321.95 per day. And so if you do the math, that's over $117,500 per year. So with Bob and Sue's savings and assets, that's not going to even cover much more than a year. So nobody likes that option. Sue says, well, Bob fell, he broke his hip, things went down from there. He went to the nursing home, he was admitted for 3 days. And they told me if he was discharged to the nursing home that, Medicare is going to pay everything. Well, Medicare covers some payment. Generally, Medicare covers days 1 through 20 in the nursing home if he's there for rehabilitation. And then days 21 to 100, it's a combination payment of Medicare and Bob's supplemental insurance. But at day 100, either Bob comes home or is discharged someplace else, or he starts private paying. One other thing to keep in mind, if Medicare runs out, is if Bob was a veteran, there are potential veterans benefits if he served during a period of wartime and was other than dishonorably discharged, and he and Sue's assets were below $80,000 under the current rules. But mostly, the biggest payment for long-term care is medical assistance or Medicaid. So we're talking to Bob and Sue when we go over that with them. And Sue says to me, which is misconception number 2, well, I know that only assets in the name in Bob's name are considered to qualify for medical assistance. She goes, Tammy and Heather, listen, we girls have to stick together. I have my little slush fund, $50,000 in a money market. I inherited it from my mom when she died. I have my daughter Rosie's name on it as a joint owner. That's my money. Bob never had any of it. He didn't give me any of it. And I had to say, oh, sorry, Sue. When you're married, 2 categories of assets, those that are available to pay for Bob's care. And when you're married, it doesn't matter if they're in Bob's name, your name, or joint names. They're all considered available. So that $50,000 money market is available to pay for Bob's care. There are also the category of unavailable assets. And again, this is different for many people, but the house is considered an unavailable asset. And Heather's going to talk a little bit about that in a minute. And other things that would be considered unavailable for Bob and Sue would be personal effects, one vehicle. If Sue had a retirement account, for example, that would be an unavailable asset. So Sue just can't get past this. She wants her $50,000. So that leads us to number 3. Pardon me. Sue says, listen, I told you, my bank account, my money market has Rosie's name on it. That account is protected. Well, Sue, is that in your Social Security number? Yeah. Did Rosie contribute any money to that? I think you told me that you inherited it from your mom. I did, but it's been that way for a long time. Can you prove that Rosie contributed at all to that account? No, she says. And I said, well, I'm sorry, that account is not protected. It's still an available asset to pay for Bob's care. And at this point, let me just say Sue is not happy. But then she moves over to Heather, because I don't think she likes all the answers I'm giving her. And Heather, what about number 4?
Misconception number 4. The nursing home takes your residence if you apply for medical assistance. So the nursing home will not take your home if you apply for medical assistance. You can still continue to reside there if you have a spouse at home. It's still protected for them during your lifetime. So it's considered unavailable or exempt during your lifetime. However, there could be a state recovery upon the death of the individual receiving medical assistance if they died with the property in their name alone and there was no spouse remaining. And we'll discuss that in greater detail as we move forward.
Okay, thanks, Heather. So at this point, Sue thinks she has another idea. She says, well, wait, give me these rules. So we have $150,000 in available assets. How much do I get to keep? Can I give it away? So the 5th misconception is I can give away all my assets and qualify for medical assistance. Well, no. So again, we add up the numbers, and under the current rules for a married couple, Sue can keep half of the available assets, $75,000, and everything that's in the unavailable column. And Sue says, well, what do I do with the other $75,000? I want Bob to get on Medicaid. We don't want to spend $117,000 a year on his care. And she leans and says, I still love you, honey, but really, I need money to live on. So she says, I'll give the other $75,000 to Rosie. How about that? Well, when you apply for medical assistance, Heather and I explained to Sue, you have to divulge all of your assets, give proof of them, and then there's a question that says on the application, have you or your spouse transferred anything without receiving fair value in the 5 years prior to the date of the application? It's called the 5-year look-back rule. And I said to Sue, if you give $75,000 to Rosie, that's going to create for a period of ineligibility for Bob for medical assistance. So you can give your assets away, but you're not going to qualify for Medicaid for a period of time. There are limited exceptions to this look-back rule, which is not really the purpose of this webinar. But say, for example, if Rosie was a child with a disability, that is one of the exceptions to the 5-year look-back rule. So then Sue looks at me and says, well, how about number 6? I can sell my house to Rosie for $1, and then I'm good, right? There's a deed. She gave me some money. And I said, well, Sue and Bob, your house, you told me, was worth $500,000. If you sell it for $1, do you think you sold it for a fair value? So we say no. We have that 5-year look-back rule to contend with. And she goes, well, can't I give anything away? What are the rules in terms of me giving something without creating a problem? So under the current rules for Medicaid in Pennsylvania, a person or their spouse can give no more than $500 total in a calendar month. It would still have to be divulged when you apply for Medicaid, but it's not going to impose a period of ineligibility. Now, I saw this the other day. Some people get confused, and so they give $500 to each of their beneficiaries. So, for example, if Bob and Sue gave Rosie $500 in December and Rodney $500 in December because they really like their son-in-law, that's going to create an issue because it's more than $500 cumulative in a calendar month. And you can't play catch up. You can't say it's December and I forgot to write those checks. So 12 times 500 is $6,000. I want to write a $6,000 check and I'm good. No, you can't. Again, $500 total in a cumulative in a month. This also includes not just gifts to children or beneficiaries, but the county assistance office who processes these applications also looks to see whether you're giving to a charity, to your church, or any place else without receiving fair market value. So again, it's one of the tricky nuances you have to be careful about. Another issue that we then related to this selling the house for $1 that we like to discuss is those pesky capital gains issues. So say they did give their house to their daughter Rosie for $1. Rosie doesn't live there. She lives elsewhere. When she received the house, she gets it at the same tax basis that Bob and Sue have. You recall I said Bob and Sue bought it for $100,000. So if it's worth $500 and Rosie owns it and she goes to sell it, she has made a $400,000 profit, just as if she were to own a stock. And so the IRS would put money, tax, depending on her income level, to cover her gain on that house. And another issue with respect to gifts with no strings to children or beneficiaries is what happens if one of them dies. So say they give the house to Rosie. She owns it. Everything's going swimmingly. And then things happen out of age order. And Rosie gets into a terrible accident and is killed. And Rosie's will says, I give everything to Rodney. And Rodney turns from the son-in-law that's loved into the not beloved son-in-law. He could sell the house and Sue would have no recourse. So by then, it's feeling sort of like gloom and doom to Bob and Sue because they really haven't planned ahead. And so they say, well, our neighbor talked about a trust. Heather, tell me about those.
Misconception number 7. All trusts protect my assets from the cost of nursing home care. So for Bob and Sue, they have a couple options. There's 2 types of trust that could be set up. The first one is a revocable trust, and the second one is an irrevocable trust. Now, the revocable trust is something that a lot of people will set up. They've heard that it's a good idea. It doesn't protect your assets from long-term care costs. That's the big issue with that revocable trust. The second trust is the irrevocable trust, and that trust will protect your assets from your long-term care costs. It's considered an unavailable asset. The explanation of it is that the settlor or donor, so if Bob and Sue wanted to set up an irrevocable trust, they would be considered the settlor, and they would not be able to access their assets that are owned by the trust directly. This is what would protect those assets from long-term care costs. This is opposite of what the revocable trust would do. The revocable trust allows the settlor to access their assets directly, which would then make those assets easy to get a hold of, and then the nursing home would tell them to pull them back out and use them to pay for their care. So back to the irrevocable trust. In regard to that, there is a 5-year look-back period when you do make gifts to the trust. You have to make it through the 5-year period in order for all the assets that are owned by the trust to be completely protected from long-term care costs.
So the minute you transfer the deed from out of Bob and Sue's name into the name of the irrevocable trust, it's an unavailable asset, but there's a consequence for that transfer. Is that what you're saying,
That
Heather?
is correct.
Yeah, that's what I thought. And so then what happens if you've done that? Say they did a trust a long time ago, more than 5 years, and they're applying for Medicaid for Bob. There's no adverse consequence.
So what could happen, and we'll move on to misconception number 8, and that is once I'm on medical assistance, my house is protected from my cost of care. So we discussed briefly before the Medicaid estate recovery, and this comes into play if 2 things were to happen. 1, you're receiving medical assistance, and 2, if you pass away with your residence being in your name alone. If you are receiving medical assistance and your residence is in your name alone upon your passing, Medicaid estate recovery will then have a lien against your estate for the amount that medical assistance paid for your care. And at that time, your executor may have to sell the residence to pay off that lien. There are some other ways to avoid this issue that we won't get into here today, but that we would be happy to share with you if you came in for an appointment.
Okay, so if Bob and Sue don't do anything and Sue dies in the car accident with Rosie, Bob could still stay on Medicaid, but the house would be at risk because
Yes.
when he dies, it's in his estate. All right, well, that's not good news, but at least they're here talking to us, Heather. So, Bob is tired of hearing Sue talk, and he finally pipes up and says, number 9, I'm the loved one. I'm already here at the nursing home. She just brought me down to talk to you. And I was told it's just too late to protect my assets. We should have done something 7 years ago when we came in to see you. Well, it's never too late to protect assets for use by your spouse or by others during your lifetime. If Bob was competent, he can do things on his own and do some planning techniques. If he's not competent, we're hoping that at least he has a good financial power of attorney document that gave Sue, his wife, the ability to do what she needs to do. So what do we mean by that? Let's go back to the math. They have $150,000 in available assets. Sue can keep $75,000, and Bob can only keep a couple $1,000s. So for purposes of our discussion, let's just round it up to their $75,000 in excess resources. Under the current law, there is a financial vehicle called a Medicaid compliant annuity. And that $75,000 in excess resources could be transferred to Sue's name. And when you transfer things out of joint names or back and forth between spouses, that doesn't create a period of ineligibility. That is permitted under the Medicaid rules. So we would put the additional $75,000 in resources into Sue's name, and she could purchase a Medicaid compliant annuity, which is a financial product that has to be irrevocable. It would pay income to Sue in the same amount every month during her lifetime or shorter, and that number is defined by a chart for Social Security for a woman of Sue's age. Sue cannot assign those monthly income payments to Rosie or Rodney or anyone else. And if Sue were to pass away, well, there are still payments under that $75,000 annuity. The beneficiary of those payments has to be the Department of Human Services to the extent that they paid for Bob's care. If Sue receives the entire $75,000, that money is totally protected from his care at a crisis. If she does not and passes on, the DHS or the Department of Human Services gets paid back only in the amount that they paid to Bob. And the remainder of those annuity payments would go to Rosie as a contingent beneficiary. So they're liking this sort of option because they're here at 0 hour. And then one more question arises. Bob says in number 10, hey, Rosie can't be liable for my care costs, can she? I heard one of the guys when I used to shoot pool said that there was a problem with one of his kids. Well, a couple things to keep in mind. First of all, contractually. If Bob was going to the nursing home, we would recommend that Bob would sign himself in. If he cannot, if his wife, Sue, is his power of attorney, or Rosie, they could sign him in, but they should sign as power of attorney. They shouldn't sign on the guarantor line. If they sign on the guarantor line, they're making a third-party contract with the facility to pay for Bob's care. But what the issue is, it's alive and well and has been so for hundreds of years in Pennsylvania, is called filial support. And that's where a spouse or a child can be liable for the care costs of a parent or a spouse, whether they're in a nursing facility, a personal care home, or at home. And there are many cases that have been resolved, and it doesn't matter if the child got the money or didn't get, was a good or bad child, they can still be liable. So if things are done correctly and you apply for Medicaid appropriately, and if you're Bob or Sue you divulge all of the facts, this isn't going to come into play, especially if you work with a certified elder law attorney. So those are the 10 misconceptions. And I want to end here with something new that you may or may not have been exposed to. Oh, Stacy's telling me and we have a question. Stacy, would you like to tell me what the question is?
Yes, we do have a question. It's what happens to the $75,000 that Sue kept? And if she passed before her husband, is that available for his care then?
Okay. So Sue bought the $75,000 annuity, and it's payable over 5 years, and she dies at the end of year 1. If I understand the question correctly, there are still 4 years or $60,000 worth of payments left on that annuity. So we would look to see what the government's paid for Bob's care during that year. And if they've paid care costs for Bob, the government would continue to get those annuity payments. It's not going to cause Bob to lose his Medicaid if he's still alive. And this gets a little bit more into the weeds and complicated, is if the spouse at home with the annuity dies before the person in the nursing home. And so that's something we would probably want to talk about in person, and it's particular for the case. Any more questions, Stacy?
Nope, that's it.
All right. So on April 20th of this year, 2017, the Pennsylvania Care Act came into place. And it's called the Caregiver Advice, Record, and Enable Act. And this is something that you may or may not have heard of, and hospitals had to implement it as of that date in April. But it allows a patient to designate a family member or other lay caregiver to help after you're discharged. And so it's on the hospital to provide in their inpatient, it's not outpatient, with an opportunity to pick somebody. So if Bob went into the hospital, he could pick Sue or Rosie or Rodney and say, they're going to be my lay caregiver. And when I go home after my hip replacement, they're going to take care of me. And so then it's the hospital's job to notify the lay caregiver when Bob's going to be discharged or transferred, talk to the caregiver, come up with the plan, and the discharge plan will include the name and the contact information of the lay caregiver, describes the aftercare assistance tasks that are necessary when Bob gets home, what all the contact information would be for services that Bob may need, the hospital employee that Bob's lay caregiver can speak with. And the lay caregiver also has to be provided by the hospital for aftercare tasks. And many of the hospitals have training videos and instructions that are given to the lay caregiver. It has to be either live or recorded, and the lay caregiver and Bob have an opportunity to ask questions. And if the patient or Bob consents, the hospital could actually release Bob's medical condition to the lay caregiver. Practically, the hospital, once Bob picks a lay caregiver, is going to talk to the lay caregiver and say, are you willing to serve? Because if Bob says, oh, it's Rodney, and Rodney doesn't want to get involved, that doesn't result in a positive consequence. And the lay caregiver can come and ask the hospital questions. Now, as I noted, the limitations with the CARE Act, it has to be hospitals with admitted patients. So it's not going to apply to people that were not hospitalized, or if it's a non-hospital facility, it wouldn't apply as well. Now, the aftercare assistance relates to Bob's condition at the time he was discharged. So if his care needs have changed and he hasn't been readmitted on an inpatient basis, it's not going to include instruction in that regard. And it's not meant to interfere with the rights of an agent under a valid power of attorney. So if Bob picks Rodney to be his late caregiver, but Sue is the healthcare power of attorney, Sue can still make decisions. Rodney's just getting information and providing the care. I want to thank everybody for joining us. What typically happens is we upload these to our YouTube channel at paelderlaw.com, and you can access them. If you are a new listener to one of our webinars and do not receive our Marshall Parker Law Alerts, it's an electronic newsletter that goes out once a month, typically on the second Tuesday. If you'd like to sign up for that, you can just send an email to webmail, webmail, at paelderlaw.com. Thank you very much for listening. We hope this is helpful. Have a great day.